Royal licenses. We now turn to the usual method adopted for change of name by any person of accepted social position, the only method, save an Act of Parliament, moreover, which the Crown fully recognizes, and that is by royal license under the sign manual and privy seal of the sovereign. This is obtained by submitting a petition to the king, lodged with an officer of arms, and transmitted by him to the Home Office, the petition being submitted to the king by the Home Secretary. It should be at once stated that the issue of a royal license is a matter of royal favor, and it cannot be demanded by anybody as a right. Nobody supposes the king personally concerns himself as to the decision, except possibly in some very exceptional case, which the Home Office in effect may leave to His Majesty's discretion. Some of the objections to particular cases raised by the Home Office are very frivolous and capricious. In petitioning for a royal license, it should not be forgotten that the terms of the license follow, with the addition of conditions, the terms of the petition. Consequently, great care is necessary in drafting the petition that it shall ask for precisely what is desired. It is possible that the will or settlement may leave no choice in the matter, but it is not an infrequent occurrence for a decision as to the order of the names, and consequently the terms of the petition to be decided by the validity or otherwise of the armorial bearings thereby affected. For example, it is idle to petition for the arms, which are to be assumed under the royal license, to be borne quarterly with the arms of the petitioner when the said petitioner possesses none. The terms of the petition being then decided upon, the petition is then drawn up in the usual form and signed, and transmitted by the officers of arms through the Home Office to His Majesty. If the prayer of the petition be granted, a royal license under the actual sign manual and privy seal of the sovereign is issued and transmitted to the College of Arms. It is there recorded, and any exemplification of the arms required under its terms is made if the same can be made according to the laws of arms. The fees upon a royal license in England are somewhat as follows. For a voluntary application to assume a name and having no reference to arms, the fees and stamp duty amount to L54, 133. Upon a royal license to assume a name and arms, the fees for the royal license and the consequent exemplification of the name and the arms amount to 121, but to this must be added the cost of establishing and proving the validity of each separate coat of arms which is exemplified in pursuance of the royal license. If the right of the petitioner to his own arms is recorded in the college, together with the right of the testator, or, if it be a voluntary application, the right of the ancestor, with the descent of the petitioner from such ancestor, whose name he assumes, there is no additional expense involved. But if it be found that all or any of the arms are destitute of authority, the cost of establishing the right thereto must be added. If the assumption of either name or arms be in pursuance of a will or a deed of settlement, there is in any case an additional stamp duty of L40 imposed by the authorities of the Inland Revenue. The fees in Dublin are for a voluntary change of name, L60, or L100 under a will or settlement, for a change of name and arms, L120, or, if under a will or settlement, L160. The stamp duty consequent upon the change being made under a will or settlement, that is, the additional L40, can frequently be saved through a little family arrangement, by making a voluntary application before the date at which the provisions of the will or settlement become operative. For instance, if a person knows that he is likely to benefit under a will on the condition of assuming a certain name, it is frequently the case that the rules governing these matters will permit a successful voluntary application to be made during the lifetime of the testator. Now the Crown has the absolute right to grant or withhold at its pleasure its license and authority for a change of name, and, if all one hears be correct, almost as many applications are refused as are granted. Needless to say, the refusals are not the personal refusals of His Majesty, but emanate from the Home Office, through which all petitions pass, and the Home Office has assumed to itself the decision as to whether or not a case shall be put forward for the personal consideration of His Majesty. In no circumstances can anyone compel either the Home Office to put forward a petition or His Majesty to grant his license. But judging from past experience, one is able to indicate generally the cases in which an application is likely to be successful. To begin with, No case has ever been known in which the Crown has refused its license for any change or assumption which is in conformity with either a will or settlement, so that it may be taken for granted that any application for a royal license in pursuance of the requirements of either a will or settlement will be granted without the least difficulty being raised. Applicants desiring to assume a name under other circumstances must show what the Crown can consider to be good and sufficient reason why the change should be effected. The refusals as to which one hears occasionally do not all seem to be dictated from identical reasons, but it is difficult to get exact particulars of such cases, and though one would hesitate to say that the granting of a royal license upon a voluntary application was a matter of the caprice of the Crown or its officers, one cannot, however, definitely say that such and such a case would be invariably permitted, or that such and such a case would be invariably refused. Certainly no positive rule can be deduced from precedent. Consequently, one can only indicate the probabilities of consent or refusal. These will usually be found to be somewhat as follows. Though as each case has its special circumstances, it is naturally difficult to speak with any certainty. An application to assume a name where no descent can be shown from any family of such name, and where it is a mere matter of personal caprice, is almost invariably refused. There are, however, precedents to the contrary. An application to assume the name of a family from whom descent in the female line exists is generally granted, if it can be shown that the female ancestor of that name through whom descent is proved was an heraldic heiress in blood, or where the applicant can show that he is an heir of line of any male of that family. An application put forward in a case of adoption to assume the name of the guardian is usually granted if the application is made by the guardian and in his lifetime, but the matter is on an entirely different footing if the application is made merely at the caprice of the ward, and after the death of the guardian when the latter has left behind him no indication of his wish that his ward should adopt his name. An application to assume the particle "de" in front of a name is usually granted where unquestionable evidence can be produced of descent from some ancestor who properly so wrote his name. A royal license is almost invariably granted to a bastard to assume the name of his putative father when the application is made by the father. But if the application is left until after the death of the father, and if the latter has left no instructions to that effect either in his will or in any settlement, the Crown requires very certain and stringent proof to be produced of the fact of the parentage before it will grant its license, and the mere presumption of illegitimate descent unsupported by evidence is not sufficient. The application of a husband to assume his wife's name, or the name of any ancestor of hers, is usually governed by the fact of the heirship or otherwise of the wife. If she be an heiress in blood the application is usually granted, but it is not infrequently refused in cases to the contrary. But the Crown does not sanction the assumption of a name by the wife whilst her husband is alive, unless the husband joins in the petition to assume the same name. The Crown, if reason is produced why its license should be granted, does not trouble to decide in what order the name shall be borne. And in cases where a royal license is granted, it is usually in the terms of the petition in which it is prayed for. Consequently, care should be taken in putting forward the petition that the request it contains shall be precisely what it is desired to obtain. Judging by past precedents, the Crown will grant its license to bear the new name in lieu of the old one, or else in addition to and before the old one, or else in addition to and after the old. It will grant its license for a name to be borne during lifetime, but not to descend to the children, or it will grant its license for the new name to descend to all the children from birth, or to the eldest son only, or, and this is a frequent limitation, to such persons as shall succeed to a certain estate or under a certain settlement. It will grant its license for a name to be assumed without reference to the arms of either family, and in that case the arms remain precisely as they were previously, and without alteration. It will grant its license for a new name and the accompanying arms to be borne in lieu of the old name and arms. It will grant its license for a new name to be assumed in lieu of an old one and the arms of the two families quarterly. It will grant its license for the new name to be used in addition to and after the old one, and for the new arms to be borne alone. It will grant its license for 2, 3, 4 or 5 names to be borne in a string, but it will not grant its license for either a name or a coat of arms to be borne or discarded at pleasure. The petition must ask for a definite thing, and if the prayer of the petition be assented to, the definite thing will be sanctioned. The arms for the last and principal surname in England will always be exemplified in the first and fourth quarters, with the arms for the first name in the second and third. But it is possible to obtain an exemplification and a royal license for two surnames to be borne together with the arms of the assumed name only, provided this assumed name is the last and principal surname, but arms for the first name will not be exemplified alone and without arms for the last and principal name. If it is desired that their royal license shall confer the right to the two crests, it is a matter of necessity that the petition must pray for the two coats of arms to be borne quarterly, and for the crest of the assumed name specifically. Royal licenses have been issued for the use of 3, 4, and even 5 distinct surnames as one compound name, but the consequent arrangement of the arms carries the subject into the highly technical laws of armorial marshalling, and need not be here pursued beyond that the arms of the last name always go first. But it should not be forgotten that a change of arms cannot be made without the interference of the Crown. With regard to the assumption of names, there are undoubtedly two widely divergent opinions held strongly by opposing advocates. There is no alternating opinion about the assumption of arms, which is admittedly absolutely illegal without the license of the Crown. A person who has persuaded himself that a deed poll or a newspaper advertisement is sufficient for his purpose, and imagines he can at his pleasure adopt the arms of the family whose name he has appropriated, will simply find he has rendered himself absurdly ridiculous, has infringed the prerogative of the Crown, and has handed himself over to the tender mercies of his many friends and acquaintances, who will be only too ready to hold him up to the ridicule his vanity and mistaken economy have richly entailed upon him. After he has borne the expenses attendant upon his pursuit and employment of unauthorized methods, and after he has accepted and lived down the ridicule and chaff of his acquaintances, and paid the other penalties of his actions, he will have the opportunity of taking the happy comfort to himself of the certain and definite knowledge that at the end of it all he will be no nearer the desired end, and will be simply using a bogus coat of arms, and using a name to which the right has still to be created, which may or may not happen in the succeeding 2 or 3 generations. When arms are exemplified under a royal license, and no blood relationship whatsoever can be shown to the family whose arms they originally were, certain marks are added to the coat of arms to indicate the fact. These marks naturally have to be such that will not interfere with the arms themselves. Usually it will be found that the mark of distinction is a plain canton upon a coat of arms, and a cross-crosslet upon the crest. Frequently, however, a cross-crosslet is substituted upon the arms for the canton if this seems more advisable, and in rare cases other charges have been introduced for the same purpose. These marks are made perpetual when blood relationship will not follow in the future, but when a husband obtains a royal license to bear his wife's surname or the surname of some ancestor of hers, the children will naturally obtain through their mother some blood relationship to the family whose name has been assumed. And in such cases the marks of distinction are governed by a special clause in the patent of exemplification under which the husband, who has no blood relationship, is required to bear the marks of distinction, whilst the children, who have the relationship, are specifically exempted from so doing. In cases of illegitimacy, a son taking his putative father's name and arms has the recognized marks to indicate the fact of illegitimacy added to the arms in the exemplification, and the royal license is only granted to him on condition that he bear these, and it is impossible at any future date for them to be discarded. But it is desirable to point out that there is one way out of the difficulty, and that is, that the condition of the bequest or settlement shall relate only to the name. It is then open to the son to obtain a grant of arms to himself without any reference to the arms of the testator, and this grant de novo will not contain these marks. But the arms would be different from the arms of the testator, and will be an entirely new coat of arms. In cases where the illegitimate child is a daughter, a certain procedure has sometimes been adopted, though whether it is still always possible, we are unable to say. This procedure is as follows. The daughter is ignored in the bequest, which is specifically made to her husband and his children, on condition that the husband assumes the name and arms. Now there exists no blood relationship, legitimately or illegitimately, between the husband and the testator, and it would be a manifest injury to the husband to require him to bear marks of illegitimacy when there is no stain whatever upon his own birth. so that the arms will be exemplified to him with the mark indicative of the absence of blood relationship. But the daughter must be absolutely ignored, as if the entail is limited to her descendants in order to exclude any possible inheritance by other children of their husband by another marriage. Then it is evident that the bequest is to the daughter and to the descendants of the old family through her bastard descent, and consequently such descendants must bear the penalty accruing to the manner of their descent. In putting forward this method of overcoming the penalty attaching to illegitimacy, it should be remarked that there is a manifest risk of the property passing in a direction which is not intended, and this risk should be well weighed before this procedure is adopted. From the point of view of the laws of arms, it is somewhat of the nature of a shuffle and is undesirable, and those endeavoring to adopt it will find that many difficulties are put in the way of its being carried out. But in every royal license which is issued the following clause will invariably be found, and to command that this our royal license and authority shall first be duly recorded in our College of Arms, otherwise this our license and authority be void and of none effect. And, moreover, if the petition and consequent royal license concern the arms in addition to the name, a clause is also inserted that the said arms shall be duly exemplified according to the laws of arms, and recorded in our College of Arms. If the petition be that of a bastard, the royal license stipulates that the arms shall be borne and exemplified with due and proper marks of distinction, and in the case of a royal license granted to a person to take the name and arms of a family, to which family he can show no blood relationship, the arms are required to be borne and exemplified with such marks of distinction as may be necessary. The Crown will not grant its licenses without the aforesaid conditions. Consequently, if the royal license in any way relates to arms, the recipient of the royal favour will find it necessary to formally establish and record the right of the person to arms under whose will or settlement he derives benefit, or, if the application be a voluntary one, the right of his nearest ancestor of the name to those arms which he is desirous to assume. Further, if the royal license requires that the arms to be assumed shall be borne or exemplified quarterly with any other coat of arms, then it at once becomes necessary to equally prove, establish and record those other arms. Consequently, it behoves every testator or settler who contemplates inserting in his will or settlement the clause requiring the assumption of his arms to take care to ascertain that he himself has an unquestioned right to those arms, and to establish and record such right in his own name and person. When this has not been done, the beneficiary is frequently involved in great expense in establishing and recording this right, and in obtaining information and details of proofs which may all the time have been within the personal knowledge of the testator or settler. Now it is a curious fact, and one singularly indicative of the vanity of a nouveau ric, that fully half of the arms, which under wills or settlements are required to be assumed, are found upon investigation to be bogus or void of authority, or, what is perhaps more frequently the case, that the right of the testator or settler to the arms which he had assumed, and which he desired to perpetuate, was absolutely incapable of proof. Now the Crown will not allow any man to meddle with the arms of a family to which he is not allied, or to which he himself could show no claim. Consequently a clause in a will which related to a specific coat of arms by description would be held to be absolutely void, unless the testator or settler himself, or his proved and admitted ancestors, unquestionably had a right to bear those arms in some manner or other, so that, if the testator desires that there shall be no question as to what arms he intends shall be assumed, he would be well advised to ascertain what are his own rights in the matter. It is seldom, however, that a will or settlement specifically details a particular coat of arms by a formal and technical description thereof. A beneficiary is usually only required to assume the name and arms of, for example, Smith. The Crown then grants its license to the petitioner to assume the name and arms of, for example, Smith, such arms being first duly exemplified according to the laws of arms in the College of Arms. The matter is thus specifically committed by the Crown to the control and jurisdiction of its College and officers of arms. It is no good kicking against the authority of the College, for the officers of arms are the officers of the Crown, and the royal license is only granted on condition that the royal license is recorded in the College of Arms, and that the arms are there exemplified according to the laws of arms. Therefore, unless the arms can lawfully be exemplified according to the law of arms, the College of Arms will point blank refuse, and rightly refuse, to exemplify them. It is not the faintest use trying to bring pressure to bear upon the College of Arms, because the officers of arms are under no control whatever save that of the Crown, whose officers they are, and that of the Earl Marshal, who has been placed in control of the College by the Crown, and neither the Earl Marshal nor the Crown will interfere, unless the arms can properly be exemplified according to the laws of arms. The frequent result is that many arms which are required to be assumed by will or settlement are incapable of lawful exemplification, and a deadlock immediately ensues. Consequently, there is a fault in the inheritance, for the license to assume the name is granted subject to a condition which, being impossible of fulfillment, renders this license absolutely void and of none effect. Though it has occasionally been held in the ordinary law courts that where the will or settlement does not specifically stipulate for a royal license to be obtained, the assumption of a name by mere motion is sufficient to justify inheritance, no law court has up to the present presumed to take upon itself to say that the assumption of arms of a man's mere motion, and without the interference of the properly constituted Crown authorities, is a sufficient compliance with the clause in a will or settlement requiring arms to be assumed. Consequently, if the will or settlement relates to the assumption of arms, which arms are incapable of lawful exemplification, the result, as we have said, is an immediate deadlock. There are two ways out of this, and, to the best of our knowledge, only two. The Crown is usually willing to grant new arms which may be lawfully borne and lawfully exemplified, in order to comply with the stipulation in the will or settlement. This is the course usually adopted, but it stands to reason and is evident that these arms are not the exact arms that the testator used and wished his successors to assume, but this is the only manner in which the Crown will permit the attempt to be made to fulfill the requirements of the will. The other method, which is but seldom adopted, but which in the eyes of the law is perhaps the safer plan, is the course which was taken in the recent case of Joyce-Cecil v. Joyce-Cecil. The course is simple. The matter is taken to the Chancery Division of the High Court of Justice, and it is demonstrated before the judge the sitting that their will or settlement contained the clause for the assumption of arms or of certain arms, that the testator or settler had no right to arms or to those certain arms, that the royal license granted in pursuance of the petition contained the usual clause to the effect that before it could take effect, arms, or these certain arms, should first be duly exemplified according to the laws of arms in our College of Arms, otherwise the royal license to be void and of none effect, that these arms, being illegal, were incapable of lawful exemplification, and that the College of Arms refused to exemplify them. Such demonstration having been made, the court will make a declaration that the condition requiring the assumption of the arms is a condition incapable of being complied with, and that therefore it is inoperative, and may be disregarded. Therefore it will be seen that the vanity of the nouveau riche, which has required the assumption of his name and of arms to which he had no right title, has simply involved his beneficiaries in the expenditure of large sums of money, and in costly litigation, without having had the least permanent effect for the furtherance of his desire. Therefore we emphatically say that it is foolish to insert a clause requiring the assumption of arms either as a condition precedent or as a condition subsequent, unless the testator had himself an unquestioned right to bear arms. Without such a right, as has been shown, the insertion of the clause will have no effect whatever, and can be eventually overridden and ignored.